touch the Russian.
Rocky pounding away at the midsection of the Russian, and he's just hit him with everything he's got.
And Drago just smiled at him.
Keep jumping away. Chop him down. Chop him down. Go, Rock.
Rocky Balboa is in serious trouble. They might have to stop this one before somebody gets killed.
Bring the grabbing. Bring the grabbing.
Rocky's hurt. He woke the sleeping giant, and now he's paying. 15 feet across the ring.
And the champ is down.
Drago continuing to punish Rocky Balboa. He just will not let him out of that corner, and Rocky Balboa is just trying to get through this first round. The Russian just threw Rocky Balboa into his own corner like a rag doll. Well, a tough first 3 minutes for Rocky Balboa. He's not only fighting what appears to be an invincible opponent, he's also fighting a very hostile crowd. There's the bell for round 2. It's been a one-sided fight so far.
It'll take more than luck for Rocky to survive this round. Rocky's been hit with bombs.
Stepping up, Rock. Stepping up.
Rocky Balboa trying to stay in the middle of the ring against the big Russian.
Move there. Do what you gotta do. Stay with him. Go for it. Go for it.
But he's fighting back ferociously. And Balboa goes down again from a right hand. Bounces right back up. Didn't do that there. Rocky Balboa has taken Ivan Drago's best punches so far. He's tired, he's bleeding, but he's on his feet. He's on the run.
He's cut! He's cut!
Russian's cut. It's a bad cut. And now it's Rocky Balboa coming after Ivan Drago. Russian wants to go on. He grabs Rocky Balboa on the throat. Balboa picking up the Russian and throws him to the ground like a wrestler. It's a gutter war. No holds barred in Moscow.
Hello, guys, and welcome to the Transparency. I want to thank you guys for being here. I want to welcome Bela. She will be doing the reading this evening. And I want to thank Bela before we even get started for beginning to tell a story based off of the official court documents, the official court record. It's Oriani versus Berry. There won't be any questions. There won't be any writing in chat or anything like that. Or this is just simply the name is very, very bold. Truth and transparency. I just want to say thank you to the mods for modding. I want to say thank you for those that are here to listen to it. And again, thank you, Bela. So I do appreciate you. Go ahead and this is
Thanks for having me here.
The case and everything that's going to come, it speaks for itself. So I rather just, there's nothing to say. So if you just want to go ahead and start reading, that'd be great.
Yeah, let's do that. So this is the findings. It's official from the court, and it starts by saying the court hereby finds that it has jurisdiction over the parties and subject matter, and the respondent was provided with reasonable notice and opportunity to be heard within the time required by Ohio law. Additional findings of this order are set forth below. The court hereby orders that the above named respondent be restrained from committing acts of abuse or threats of abuse against the petitioner and other protected persons named in this order. Additional terms of this order are set forth below. And I just want to say that there's two people that are named in this order, and it's Lana and her minor child that are protected. The terms of this order shall be effective until 11:59 p.m. on 3/2/2026.
Bella, can you start the reading over from the beginning just because it did a copyright because of the music? So if you could just start from the beginning.
Sure.
Thanks.
So let's start again. This is from the official reading of the official court record. It says the court hereby finds that the jurisdiction over the parties and subject matter and the respondent was provided with reasonable notice and opportunity to be heard within the time required by Ohio law. Additional findings of this order are set forth below. The court hereby orders that the above named respondent be restrained from committing acts of abuse or threats of abuse against the petitioner and other protected persons named in this order. Additional terms of this order are set forth below. And I wanted to note here that the protected parties are Lana Oriani and her minor child are protected. The terms of this order shall be effective until 11:59 p.m. on 3/2/2026. This proceeding came for a hearing on November 21st, 2022 and January 13th, 2023 before the court in the Civil Stalking Protection Order ex parte or Civil Sexually Oriented Offense Protection Order ex parte issued on 7/20/2022, all in accordance with RC 2903.214. The following individuals were present: the petitioner and the respondent. And these are the findings. The court hereby makes the following findings of fact. This matter came before the undersigned magistrate on November 21st, 2022 and January 13th, 2023 for a final evidentiary hearing on petitioner's request for a civil stalking protection order, a CSPO, against respondent. The parties appeared pro se and presented their sworn testimony. Petitioner also presented sworn testimony from witness number 1, Mod Squad, Kraft and Barnes, and respondent on cross-examination. Petitioner submitted numerous exhibits into evidence. Respondent was permitted to display recordings during the hearing as the proceedings were being recorded. As to the evidence of text communications, the magistrate notes that only the communications between respondent and Kraft and Barnes were considered. After careful consideration, the magistrate recommends that the CSPO be granted based on the findings set forth below. The magistrate will first set forth the applicable law, and we're redacting the case law that the magistrate uses. In determining the credibility of each witness, the court considered the appearance of the witness, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he testified, his accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with common sense and all the facts and circumstances surrounding the testimony. The court is free to believe all, some, or none of the testimony of each witness. Factual findings and analysis. The magistrate will begin by noting that the parties presented their evidence in a disjointed and convoluted manner, making it difficult to discern a clear timeline of events and to comprehend how certain individuals and situations related to the matter at hand. Only the magistrate suffered this handicap. The parties never seemed impeded, as each appeared to understand the context of the opposing party's evidence. The magistrate was able to glean the following. On March 26, 2021, petitioner launched a YouTube channel, Truth and Transparency, which displays content that is part of the true crime genre. During this time frame, petitioner also started a nonprofit organization that is related to her interest in true crime cases. When she started her channel, much of petitioner's content was focused on the notorious Watts family murder case. Petitioner's unique take on the case attracted not only followers, but online critics and trolls, one of them being Respondent. However, when petitioner was in the process of seeking participants for a mock trial, Respondent reached out and apologized for being, quote, sassy and, quote, trolling petitioner. Respondent asked to be a mock juror and claimed to now be a fan of petitioner's channel. Petitioner accepted her apology, but told the moderators of her channel to, quote, keep an eye on this person. Petitioner testified that their friendship dissipated quickly over the ensuing months because Respondent was into drama, porn sites, and trolling other online creators. The evidence shows that what ultimately led to the parties falling out was a situation involving an anonymous individual using the moniker Shift Happens. When Shift Happens first began, quote, trolling petitioner, she blocked him or her. Respondent then informed petitioner that she was, quote, harassing Shift Happens, but petitioner wanted no part of it. Petitioner became vested in the matter when it came to her attention that Shift Happens was divulging personal information about her online. Petitioner then discovered that Respondent was actually working with Shift Happens. This upset her, and the parties' relationship ended in the fall of 2021 when Respondent refused to divulge the identity of Shift Happens. The evidence shows petitioner reacted poorly to the breakdown of their friendship and divulged information about Respondent online. This backdrop brings us to the basis for this action. Petitioner asserts that, in retaliation, Respondent has waged a relentless campaign to essentially ruin her life. Petitioner believes Respondent seeks to ruin her businesses, her family, and even wants her imprisoned. Petitioner seeks protection on the grounds that Respondent's unremitting harassment and presence in her life is causing her an enormous amount of mental stress. Petitioner's witnesses, Kraft and Barnes, witness number 1, and Mod Squad were integral to substantiate her claims. These individuals were highly credible. Mod Squad volunteers for petitioner's nonprofit business and is a moderator on her YouTube channel. Mod Squad became acquainted with Respondent through the internet as they were part of the same Facebook groups. Mod Squad was aware that petitioner did not initially trust Respondent, but decided to give Respondent a chance once Respondent apologized for trolling her online. Mod Squad formed a friendship with Respondent. When Respondent's online behavior started becoming, quote, erratic, and petitioner wanted to block Respondent from her channel, Mod Squad asked her not to, stating Respondent was her friend. Mod Squad, petitioner, and the other moderators of petitioner's YouTube channel communicated through an ongoing private text message group. In the, quote, moderator chat, petitioner began to question who Shift Happens was and asked why this anonymous troll seemed to know so much about her. Pursuant to her standard operating procedure, petitioner blocked the account from her channel, thinking that would take care of the matter. However, Mod Squad observed that Shift Happens began making strange videos on YouTube about Petitioner, calling Petitioner a liar, and making efforts to have Petitioner's channel removed from YouTube. Mod Squad testified that videos were harassing and they were oddly vast in number. Significantly, Mod Squad credibly testified that in the fall of 2021, Respondent divulged that she developed a friendship with Shift Happens and knew this person was against Petitioner. Respondent ominously expressed that she has never created a hate channel or been part of a, quote, smear campaign, but will now. She intimated that she wanted Mod Squad to join their cause against Petitioner. Mod Squad refused and could not get Respondent to disclose Shift Happens' identity. Thus, she severed her friendship with Respondent at that time. Subsequently, Mod Squad observed that Respondent began posting video after video disparaging Petitioner and exposing personal and confidential information. From the context, it was clear some of the information had come from the, quote, moderator chat, which Respondent was not a member of. Mod Squad credibly testified that in one of the videos, Respondent boasted that she had hacked into Petitioner's accounts. In one of the videos, Respondent even posted an excerpt of the moderator chat. Mod Squad credibly testified that this caused herself, Petitioner, and other moderators mental distress as they were concerned that Respondent would release their private information. Witnesses, witness number 1 and Kraft and Barnes, corroborated the existence of the smear campaign against Petitioner. Witness number 1 began watching Petitioner's YouTube channel at its inception. Witness number 1 was not a, quote, fan of Petitioner's content and became acquainted with Respondent as both were critical of Petitioner within their online community. Near the end of 2021, witness number 1 was approached to become part of, quote, Operation Takedown Lana Oriani. While it is not clear who initiated the campaign, witness number 1 credibly testified that Respondent was a member of this group. Their stated goal was to, quote, ruin Petitioner's life in all aspects. Witness number 1 was candid that she was willing to participate because she did not like Petitioner. Witness number 1 credibly testified that the group members organized to go live on YouTube at designated time slots, which she referred to as systematic hits. They relentlessly took turns targeting Petitioner by displaying content designed to paint her in a bad light. Their overall purpose was to, quote, drive her crazy and, quote, trigger her into reacting poorly in her video responses. They then compiled and collected data from Petitioner's video reactions, packaging it neatly and nicely into evidence they used to tarnish her reputation. Petitioner presented herself to be a dramatic and emotional person. It appears she often took their bait, giving them much fodder to then use against her and make her look like the crazy one. In January of 2022, an individual identified as Vanessa Walsh filed a lawsuit in Colorado seeking a stalking protection order to be issued against Petitioner. On January 17th, 2022, Respondent encouraged members of the group to watch Petitioner's YouTube channel that day and to record Petitioner. Witness number 1 was not sure why the request was being made, but she could tell something was happening. Petitioner's live broadcast on her channel was interrupted by a gentleman loudly banging and yelling at Petitioner's front door. Petitioner played the video, which corroborated witness number one's testimony that it was a frightening situation. Petitioner and her minor child were visibly scared. Incredibly, the individual at the door was a process server and was there to serve petitioner with the Colorado petition. While it is not clear how respondent knew petitioner would be served that day, witness number one credibly testified that respondent was the one who informed members of the group to be watching. The process server's conduct was beyond inappropriate. Witness number one testified that the group members then had discussions about informing petitioner's ex-spouse about what had occurred to let her know petitioner was not providing a safe environment for their son. From being a member of the group, witness number one has personal knowledge that respondent created a, quote, Lana Oriani hate channel in the beginning of 2022. Witness number one credibly testified that respondent urged members of the group to provide her with content to use against petitioner. Additionally, witness number one testified that respondent's goal was to trigger petitioner into committing conduct that could be a violation of the protection order issued by the Colorado court. Respondent told witness number one that she wanted petitioner, quote, arrested and put away in handcuffs. In July of 2022, witness number one began to question some of the things respondent and others were stating about petitioner. For instance, witness number one did not believe the accusation that petitioner had poisoned a dog. Additionally, respondent was claiming on her YouTube channel that petitioner hired a, quote, hitman to murder her ex-spouse. Witness number one was aware that respondent contacted petitioner's ex-spouse's counsel with this allegation. Witness number one was aware that witness number one was compelled to come forward and divulge to the petitioner the existence of the group and, quote, Operation Takedown Lana Oriani. She testified she felt a moral responsibility to help petitioner when she realized that the group was in fact impacting petitioner's relationship with her minor child. Petitioner provided evidence that in July of 2022, her ex-spouse filed a motion to modify custody, stating petitioner could not provide a safe environment, thus giving credence to witness number one's testimony that Operation Takedown Lana Oriani was accomplishing its goal to interfere in petitioner's life. Crafton Barnes operates a YouTube channel and similarly knows the parties through their online presence. He also did not initially like petitioner and admits he created online content critical of her. In the fall of 2021, respondent began sending him extensive communications regarding petitioner. She told him in November that she was about to take petitioner on. She further wrote, quote, I'm getting under her skin and I'm getting pleasure for it. Craft incredibly testified that respondent was making efforts to have petitioner evicted from a residence in Pennsylvania, where respondent erroneously believed petitioner was living. Respondent sent Crafton a screenshot of a glitter dick bomb, stating she wanted to send it to the petitioner. Petitioner, in fact, did receive this glitter dick bomb in the mail, which exploded when opened by her son. Respondent denies she caused the package to be delivered to petitioner, but admits she knows who actually did. Respondent's denial was not credible. Crafton testified that respondent has made over 300 videos displaying content about or disparaging petitioner. He believes she became extremely obsessive about the plot to take down petitioner. Crafton testified that respondent would purposefully hashtag petitioner's name when posting these videos. He explained her purpose in doing so was to cause these videos to come up every time petitioner's name is searched online. After a while, Crafton became uncomfortable with his participation in this scheme. He believed he was being lied to. Like witness number 1, he came forward and divulged the existence of Operation Takedown Lana Oriani to petitioner. He further gave petitioner a copy of the hundreds of text messages between him and respondent. These text messages substantiated his testimony that respondent was obsessed with the ongoing plot to harass and take down petitioner. Normally, a petitioner approaching the court, crying that the respondent is trying to, quote, ruin my life, would sound hyperbolic. But petitioner's witnesses credibly established that this is in fact true and that respondent is acting with such a motive and purpose. Respondent did not deny making hundreds of videos about petitioner. Notably, she titled many of the videos in such a way that she was openly speaking and directing petitioner to watch. Additionally, she often tags petitioner's YouTube channel in the title of her post, thus directing the video to petitioner. Besides the online harassment, respondent has admittedly taken more severe steps to personally impact petitioner's life. Respondent admits she has contacted the police and reported some of petitioner's online activities. She emphatically expressed that she believes petitioner should be in jail. Respondent's pursuit of petitioner's freedom continues to date. Respondent ominously dropped during her testimony that she has even been communicating with the FBI about petitioner. Respondent evacuated about whether she contacted the FBI or whether the agency first contacted her. Regardless, respondent conveyed to the undersigned that she wanted to get a reaction from petitioner, and she seemed to enjoy disclosing this tidbit. Respondent admits she contacted petitioner's ex-wife's counsel. Respondent claims she had a moral obligation to do so because she came across information suggesting petitioner is seeking to hire a hitman to murder her ex-wife. Respondent played an audio recording of a conversation between petitioner and another individual to prove this salacious accusation. The recording did no such thing. Rather, respondent's possession of the recording only served to substantiate petitioner's claim that respondent has infiltrated her life and has access to her private dealings. Respondent then claimed that she saw evidence of petitioner trying to hire a hitman from the moderator chat messages. When cross-examined about these messages and how respondent viewed them, respondent ominously expressed that she was in fact part of the group, but petitioner did not know it. Respondent then refused to explain her statement any further, affecting her credibility. Respondent appeared to be suggesting that she has secretly been surveilling petitioner, leading credence to the petitioner's claims. Respondent asserts that all of her actions were in response to conduct committed by petitioner and that she is the victim. However, the evidence actually showed the opposite. The petitioner is poorly reacting to respondent's deliberate intents to trigger her. Respondent further contends that petitioner started it. Even if this is true, neither RC 2903.214 or 2903.211 requires that a person seeking a CSPO must have clean hands in order to pursue and obtain relief. Holding that the domestic violence, okay, that's just part of the case law. Respondent also urges that none of her conduct is illegal. However, even when conduct consists of legal acts, a person does not have constitutionally protected right to engage in behavior when they are knowingly causing another to believe he would cause her physical harm or mental distress. State versus Smith. While actions taken alone may not rise to the level of criminal behavior under 2903.211, that determination changes when considering a cumulative effect of these encounters along with the intent to cause upset. The magistrate will be blunt. The parties are individuals who embroiled themselves in a dramatic and sophomoric online feud that, frankly, they should not be bothering the court system with. If petitioner want to continue to live online presence, then she must accept that she will be the victim of criticism and online trolls. However, the facts of this case present a unique situation. The competent and credible evidence establishes respondent is waging a smear campaign against petitioner, and her admitted aim is to see that the petitioner is jailed. Respondent has taken active steps to affect petitioner mentally and to impact her business, personal, and family interests. Respondent has an unnatural obsession with petitioner, and her own testimony suggests she has means and the ability to secretly infiltrate petitioner's life. Respondent's conduct far exceeds the bounds of merely being a pesky internet troll. Petitioner provided by the preponderance of the evidence that respondent has engaged in a pattern of conduct that has caused petitioner to believe respondent will cause her mental distress. Importantly, the court cannot issue orders prohibiting respondent from making disparaging videos about petitioner or from contacting authorities and raising concerns about petitioner. Such restrictions would likely run afoul of the First Amendment. However, a CPO is designed to, among other things, protect a petitioner from emotional violence and provide the petitioner a measure of peace of mind. Petitioner provided that respondent's actions are causing her mental distress. Who would reasonably want to have any contact with someone who actively seeks to have them imprisoned and for her child to be taken away? The magistrate would further underscore that the greater weight of the evidence provided respondent has a The magistrate would further underscore that the greater weight of the evidence proved respondent has a relentless goal to drive petitioner crazy and seems to derive satisfaction in doing so. Thus, petitioner rightfully petitions the court to prevent respondent from contacting her any further. The court can enter restrictions prohibiting respondent from doing so. For instance, respondent can be refrained from tagging petitioner's name or YouTube channel on her posts, as this is a means for respondent to contact petitioner. Additionally, respondent can be ordered not to electronically monitor petitioner, which would include her secret surveillance of respondent's private moderator chats. However, the magistrate will emphasize, for petitioner's benefit, that the court simply cannot order respondent not to speak about, defame, or disparage her. If respondent continues to make videos about her, petitioner simply should not watch them. Her more appropriate remedy to enjoin such conduct is to file and prove a defamation action. Petitioner proved by the preponderance of the evidence that respondent has engaged in a pattern of menacing and harassing conduct that has caused petitioner to believe respondent will cause her mental distress. The evidence warrants issuance of a CSPO. Petitioner's request for a CSPO shall be granted for 3 years. The court will retain jurisdiction to modify, terminate, or extend the terms of the CSPO for a term of up to 5 years. So the findings are: A, finding of menacing by stalking pursuant to revised code 2903.211 and 2903.214. You can read about that. And then the magistrate has said that the respondent knowingly caused the petitioner, protected person, to believe that the respondent will cause mental distress, and it's defined as a mental illness or condition that involves some temporary substantial incapacity or any mental illness or condition that would normally require psychiatric treatment, psychological treatment, and other mental health services, whether or not any person requests or receives the treatment or any other mental health services. And the court finds by a preponderance of the evidence that one, respondent has knowingly engaged in a pattern of conduct that caused petitioner to believe respondent will cause physical harm or has caused mental distress. And two, the following orders are equitable, fair, and necessary to protect the persons named in the order from stalking offenses. And I need to remind everybody that the people who are protected is Lana and her minor child. And respondent shall not abuse, harm, attempt to harm, threaten, follow, stalk, harass, force sexual relations upon, nor commit sexually oriented offenses against the protected persons named in this order. And the respondent shall not enter the residence, school, business, place of employment, daycare centers, or child care providers of the protected person named in the order, including the buildings, grounds, parking lots at those locations. Respondent may not violate this order, even with the permission of a protected person. Respondent shall stay away from the petitioner and all other protected persons named in this order and not be present within 500 feet of any protected persons, wherever those protected persons may be found, or any place respondent knows or should know the protected persons are likely to be, even with the protected person's permission. If the respondent accidentally comes in contact with protected persons in any public or private place, respondent must depart immediately. This order includes encounters on public and private roads, highways, and thoroughfares. Respondent shall not initiate or have any contact with the protected persons named in this order or their residences, businesses, places of employment, schools, daycare centers, or child care providers. Contact includes, but is not limited to, landline, cordless, cellular or digital telephone, text, instant messaging, fax, email, voicemail, delivery service, social media, blogging, writings, electronic communications, posting a message, or communications by any other means directly or through another person. Respondent may not violate this order even with the permission of the protected person. Respondent shall not use any form of electronic surveillance on protected persons. Respondent shall not cause or encourage any person to do any act prohibited by this order. And this was sent to both of them, the petitioner and the respondent. So I think that's it, right, Ella?
Yep. I think that's it. The other case is Oriani versus Walsh. I mean, your voice is way better, but I can read that one.
Yeah, read it on mute.
Okay, hold on one second. Go ahead and mute. I'll try to back up that voice here. This was the magistrate's decision on January 31st, 2023. This matter came before the undersigned magistrate on January 10th, 2023 for an evidentiary hearing on petitioner's request for a civil stalking protection order against respondent. Petitioner is Oriani, respondent is Walsh. Petitioner appeared pro se. Respondent and her counsel appeared via video conferencing. Respondent moved to dismiss this matter for lack of personal jurisdiction and on grounds that the claims were barred by the doctrine of res judicata. The magistrate determined that these affirmative defenses could not be resolved solely based on the allegations in the petitioner or in the petition and would require further evidence. For issues of judicial economy, the magistrate ruled that the hearing on the affirmative defenses would be consolidated with the trial on the merits of the petition. Petitioner presented her sworn testimony and testimony from Kraft and Barnes. Petitioner's exhibits 1, 2, and 4 through 12 were admitted into the record. Following the close of petitioner's case, respondent moved for a dismissal of the petition pursuant to Civil Rule 41B2 for reasons set forth on the record as well as below. The motion to dismiss is well taken and is granted on the grounds petitioner has not shown a right to relief under RC 2903.214. Because respondent prevailed on her CR 41B2 motion, at this time, her request for a dismissal based on application of res judicata is found to be moot. Standard of review and applicable law. She cites case law that is being redacted, factual findings and analysis. Because respondent's motion for dismissal pursuant to Civil Rule 41B2 was granted on the record, respondent did not present any evidence in her defense. Thus, this analysis is based on a one-sided version of events. The magistrate notes that petitioner's presentation of her evidence was at times convoluted and disjointed. The magistrate gleaned some basic facts. Petitioner and respondent operate YouTube channels. Petitioner's channel is called Truth and Transparency, while respondent's channel is named Unmasked. The parties primarily create content that is part of the true crime genre. Through their internet presence, the parties' paths crossed. They initially were on friendly terms or at least did not have an adverse relationship. In August of 2021, the parties were in communication. Respondent sought petitioner's help in identifying who was behind certain internet postings that were concerning to her. According to a petitioner, respondent then blamed her for conduct she was not involved in. Petitioner believes respondent may have acted mistakenly. However, petitioner also posted that Respondent knows the truth and maliciously, falsely accused her. Regardless, petitioner presented evidence to show that respondent then engaged in a campaign of harassment designed to ruin her life, recruiting others to accomplish this goal. Petitioner sought to prove this through the testimony of Crafton Barnes. Mr. Barnes is also a YouTube content creator and was familiar with the parties through the internet. He was a member of Respondent's Facebook group known as quote-unquote Unmasking Chris Watts. Mr. Barnes and petitioner initially had a so-so relationship and would exchange jabs at each other online. In early January of 2022, an individual identified as Vanina Sucketal, a California-based attorney, sent Crafton Barnes a private message asking him to be part of quote-unquote Operation Takedown Lana Oriani. The magistrate notes Mr. Barnes testified as to where this monkey ear came from. And when he did so, he did not know initially who said it, but then testifying to Miss Sucketal, known as Nina, used the slogan in their private chats. Mr. Barnes understood the purpose of the operation, which was to quote-unquote ruin petitioner professionally and financially and to interfere with her child's custodial relationship. Mr. Barnes and Nina discussed methods and tactics on quote-unquote how to destroy petitioner online. When Mr. Barnes indicated a willingness to participate in these goals, Nina created another private chat group that included respondent, Mr. Barnes, and Nina. Mr. Barnes wanted to quote-unquote help these women because they were claiming petitioner was engaging in conduct that placed their lives and their families' lives in danger. He was additionally led to believe that petitioner was threatening to release his private medical information on the internet. The record shows Mr. Barnes, respondent, and Nina had extensive communications throughout January and then continued corresponding through April of 2022. The magistrate has reviewed these messages. The substance of the conversation is sometimes difficult to follow. At times, the participants discuss other individuals or speak about matters without necessarily context for the undersigned to decipher whether they are conversing about petitioner, but some of the messages are clearly about or related to petitioner. There are comments made about reporting petitioner's YouTube channel or her nonprofit organization. Additionally, respondent stated that she believes petitioner's son is not safe. The participants discuss the fact that the petitioner's ex-wife's divorce attorney needs to be sent this information. The group chat contains references to a quote-unquote sex panel. Mr. Barnes explained that he was a participant in a panel that conducted a live broadcast event on YouTube where the members falsely claimed that petitioner was a sexual predator and sexually harassing them and doing other illegal acts. Mr. Barnes testified that respondent was not involved in the panel. On January 6th, Mr. Barnes talks about quote-unquote manufacturing parody phone calls and creating parody videos. He states, quote-unquote, "This is me saying game on," end quote, Respondent replies with a heart emoji, then expresses, "It's time for game on. She's trying to blackmail me too. Fuck it." Mr. Barnes took this as a derivative for him to begin harassing petitioner. On January 11th, respondent states, January 11th, 2022, respondent states that she needs to, quote unquote, get a restraining order ASAP. And, quote unquote, she said she's going to bury me. This woman is completely off the rails, end quote. At 2 a.m. Eastern Standard Time, they discussed this, that the petitioner was, quote unquote, spiraling out of control and seems unhinged more than usual. Respondent comments that she, quote unquote, added some, quote unquote, to the pile for the cops too, notes. The participants talk about doing daily or mass reporting of petitioner's YouTube channel for nudity and sexual content. When Mr. Barnes states he had already made a report, respondent states, "I reported it too." Later that day, Nina states, "I'd like for us to set up a group of people who we trust to get the ball rolling, divide up the tasks, do a share drive, and prepare reports with affidavits if needed." She subsequently comments in quotes, "And when I'm done with my thesis conclusion, perhaps we can set up a Zoom and do a three-pronged strategy. 1, evidence, report her channel. 2, report her nonprofit. 3, get the press involved." Respondent replied with a thumbs up emoji to this statement. Mr. Barnes testified that he made parody videos about petitioner in furtherance of the takedown scheme. He believed that other individuals were creating similar content as part of respondent's quote unquote team. He expressed the goal was to galvanize negative attention on petitioner, as well as to harass, abuse, and intimidate her. While the private chat messages show Mr. Barnes remained aligned with respondent and Nina in the ensuing months, he testified that as he got to know petitioner, he realized the things being said about her were not true or not provable. When you asked for proof, nothing would be provided. There was no evidence presented regarding the circumstances of petitioner and Mr. Barnes, quote unquote, getting to know each other. In early May of 2022, Mr. Barnes provided petitioner a copy of the group chat and came clean about his involvement in Operation Takedown Lan Oriani. Mr. Barnes expressed that in good conscience he could not continue to be part of the scheme. He wanted to be transparent about his role, and he wanted petitioner to have justice. Thus, much of petitioner's case against respondent is based on the statements made in the group chat and Mr. Barnes' testimony that respondent spearheaded a takedown scheme to ruin petitioner's professional and financial life, as well as to interfere with her family relationships and to place her in jail. Petitioner also presented evidence regarding another matter between the parties. Notably, respondent filed for and obtained a quote-unquote lifetime protection order against petitioner in respondent's home state of Colorado. The Colorado protection order was issued in March of 2022, March 7th, 2022. Following a full evidentiary hearing in which petitioner presented a defense. Petitioner presented testimony and evidence to advance her claim that the protection order was fraudulently or erroneously issued, being based on quote-unquote bullshit and perjury. The protection order proceedings have provided much fodder for other YouTube creators. Petitioner presented evidence to show these content creators are part of the quote-unquote takedown campaign, are being fed information about the case by respondent and releasing it to the internet at her direction. This causes petitioner great distress. Petitioner presented evidence that in July of 2022, Respondent filed a motion for contempt, alleging that she had violated the protection order and was seeking the imposition of a jail sentence. Petitioner testified that the motion is based off of falsehoods and was filed to further Respondent's campaign to ruin her life. Petitioner further presented evidence of wrongdoings committed by others, particularly an Aunt Lala and a Father Snuffles, which appear to be the monk ears of Alicia Berry Farrar and James Rosakos, respectively. Mr. Barnes testified that Aunt Lala was mentioned in the group chat as someone who would assist them in their plot because this person disliked Petitioner. Mr. Barnes testified that Mr. Rosakos is quote-unquote known in the community to be Respondent's manager. However, he admitted that he is not familiar with the business structure of Respondent's YouTube channel. Petitioner seeks to hold Respondent accountable for Aunt Lala and Father Snuffle's conduct. Petitioner additionally presented evidence that on August 3rd, 2022, Respondent went quote-unquote live on her YouTube channel and for about 2 hours discussed the issues between the parties, calling Petitioner her quote-unquote stalker. Petitioner subsequently initiated this proceeding on October 18th, 2022, seeking a CSPO against Respondent. At the time of the filing, Petitioner waived her right to request an ex parte order of protection. Instead, Petitioner was solely requesting the matter proceed to a full hearing. Respondent was served with a copy of the petition and notice of the full hearing dated on October 27th, 2022. Both documents plainly indicate Petitioner did not request an ex parte emergency order. Petitioner provided evidence that Respondent posted the following comment to her social media. Quote unquote, "Bless her heart. Let the credible one explain what actually occurred. My badass lawyer got approval from the Ohio Supreme Court to represent me in this case due to the fact that my court-declared stalker is trying to retaliate and be associated with me," in parentheses, see definition of stalker, "by filing a bunch of crap in Ohio. I won't go into any other details as those shall reveal themselves. I will say that unlike my TPO against my stalker, there was no ex parte granted in her case for lack of evidence." Shocking. "This is just further stalking by my stalker, which has become a really oppressive, creepy way of life for me over the past year. If you'd like any other actual information, actual facts, let me know." Finally, Petitioner presented evidence that Respondent posted the following comment on Father Snugglenut's YouTube channel. In quotes. "Yep, these two are repulsive, and neither are any type of victims. This has become ridiculous. These people are spineless, immoral, gaslighting, manipulative pieces of crap, and they aren't even good at it. Crafton and Kim are fine exploiting and harassing others. They are the definition of creators that go real life. They can't handle any spotlight on their behavior, though. I've noticed that all of these types have the same traits. They're all so weak and cowardly unless terrorizing others. I've learned to laugh at a lot of the hypocrisy. I'd actually feel sorry for them if they weren't harming so many others. Meanwhile, Crafton is another shitbag's character witness. You can't make this shiz up. I'm not a person that can pretend to be this stupid." End quote. Petitioner testified that the post was designed to harass and intimidate her witnesses in this case and others and other pending cases. I need to get some water there. My throat, man.
Can you repeat that part about you never asking for an ex parte? Because I think that's just so important, because it was put out there that you did. So
Yeah, I never asked for an ex parte. And then when they asked for a continuance, this person went online and posted, and that's why the judge made it clear that respondent was served with a copy of the petition and the notice for the full hearing. Both documents plainly indicate petitioner did not request an ex parte emergency order. Nothing was ever denied. But after a court date that we had, she took to the internet to blatantly lie about what transpired, only to gaslight people. Petitioner testified that the post was designed to harass and intimidate her witnesses in this case and her other pending cases. The magistrate ruled on the record that petitioner's evidence was insufficient to meet her burden of proof under RC 2903.214. This conclusion was not reached lightly. It would have been preferable for the undersigned to render a decision based on a fully developed record and upon weighing the merits of evidence presented from both parties. While not required to under Civ Rule 41B2, the magistrate has viewed the evidence in petitioner's favor and has ignored the attempts to discredit her. If respondent had presented a defense, the undersigned would have been in a better position to render credibly based conclusions. The magistrate perceived she was expected to pick up on cues that petitioner is a quote-unquote deranged stalker who frivolously filed this action to retaliate and further abuse and harass respondent. Petitioner came to court armed with corroborating evidence and a supporting witness. One cannot read the group messages between respondent, Nina, and Mr. Barnes and then possibly conclude that the petitioner, in quotes, "You're crazy to think that they were plotting against you to disrupt your family and business interests." This is not a finding, though, that these actors committed tortious or illegal acts, but from the evidence presented, the magistrate finds petitioner brought this case in good faith and with a sincere belief she is the victim of harassment and stalking. Additionally, the fact that the respondent has a lifetime protection order in place against petitioner, while significant, is not necessarily dispositive. I'm redacting court case law. Petitioner's strongest evidence was Mr. Barnes's testimony and the group chat messages between him, respondent, and Nina. Importantly, the messages themselves cannot be grounds for an issuance of a protection order. A CSPO can only stem from conduct committed with knowledge the actor was causing a party to be in fear of physical harm or to incur mental distress. This was a private chat message, and the substances of the conversation conveys the messages were not to be shared with petitioner. Given the apparent animosity between the participants and petitioner at the time the group was created, Respondent had no reason to believe her statements would ever be seen by petitioner. Thus, while petitioner finds the communications to be harassing and upsetting, respondent was not knowingly menacing her in making the statements. The messages are relevant to prove motive and purpose and to corroborate whether respondent committed menacing conduct towards petitioner. From the undersigned's review of the messages, Nina Vanina Sucketall appears to be more of the mastermind California lawyer, the individual spearheading the campaign to quote-unquote take down petitioner. Respondent's messages convey that she was angry and upset because of perceived wrongs committed by petitioner. Perhaps, as petitioner asserts, respondent was misguided. But the magistrate cannot conclude respondent was purposely targeting an unknown innocent. This would not provide respondent license to engage in menacing conduct. Petitioner contends that respondent actively participated in the takedown scheme in many ways. Petitioner relies on respondent's admissions within the chat that she has reported petitioner's YouTube channel and her nonprofit organization. Petitioner also presented evidence to attempt to show respondent's Colorado filings were frivolous. She accuses respondent of committing perjury to obtain a stalking order. She further asserts respondent and even respondent's counsel presented falsehoods in the motion of contempt for purposes of having her falsely imprisoned for violating the protection order. Petitioner believes respondent is quote-unquote weaponizing the Colorado protection order to torment her. Assuming it is proper for petitioner to re-litigate the merits of the Colorado action here, petitioner's evidence was insufficient to prove that the Colorado filings were all a sham. Petitioner attempted to pick apart some of the evidence presented by a respondent in that matter to show she lied and thus that the case was improperly decided. However, petitioner did not admit the Colorado decision into evidence. I fucked up and didn't. You can say, here's the evidence. You know this, you know this. You have to say, we would like to put this into evidence. I fucked up there. The 216 pages of the transcripts of the findings from my Colorado case was not admitted into evidence. However, petitioner did not admit the Colorado decision into evidence. The magistrate does not know on what grounds the ruling was. The reason that they did not get admitted into evidence, she had the binder. When she opened it, there was writings on it because it had all my notes on it. And I said, oh, that's okay. Here, I'll take that back. I have different parts stapled together. And as I start talking about them, I will start admitting them. And as I was doing that, that's what ended up happening. But there is a kicker to that when we come back, because just keep listening. So as I was doing what I was doing and explaining everything, in order for anyone to know why the magistrate would rule and award me something, it's because the magistrate found her testimony at the Colorado hearing to be credible, and that I was not credible, and that she was the only credible witness there today. And had that magistrate on January 10th or 13th had that in her possession, like she had in her possession before I took it back, because I didn't want to admit evidence that had been marked on. But her, but just so you guys understand how that works. But there is more to explain how that does come full circle, and I do believe it's going to help me here in the end. Because God works in mysterious fucking ways, I'll tell you that.
Are you going to really explain it, though?
I'm going to go on to read. Again, however, petitioner did not admit the Colorado decision into evidence. The magistrate does not know on what grounds the ruling was made, and petitioner's minimal evidence is inadequate for the undersigned to conclude that the Colorado court, quote unquote, got it wrong, or that the case was based entirely on, as petitioner claimed, quote unquote, bullshit. Next, even if petitioner had proved the Colorado filings are a sham, this type of conduct, as well as respondents' purported reporting of petitioner's YouTube channel and or nonprofit and interference with petitioner's child custody, is not actionable under RC 2903.214. Petitioner is distressed because she believes respondent is actively trying to ruin her professional and personal life. It is unfortunate that societal reality that people cause harm and mental distress in numerous ways, including injuring persons, property, or reputations, or through interference with freedom, contracts, property, rights, parental rights, family relationships, employment, or business relationships. However, RC 2903.214 does not provide redress for all wrongful acts. Rather, if a party meets her burden of proving menacing by stalking, then it will permit to issue any protection order containing terms designed to ensure the safety and protection of the subject. The aim of RC 2903.214 is to protect people, not reputations and business interests. It does not provide remedy for mental distress that arises from civil torts, such as defamation, intentional interference with business or family relationships, which is why at the same time that I filed this, I filed a 5-count defamation listed out civil torts against Miss Walsh and her business, Unmask, as well as James Rosakis. That was filed on October 20th, 2022, that I filed my lawsuit against Vanessa Walsh, James Rosakis, and Unmask for $500,000. Continuing on, there's more. There's a lot more. Okay, here we go. Petitioner cannot use RC 2903.214 to right these alleged wrongs. More appropriate civil remedies are provided through actions for defamation, abuse of process, and intentional interference with business or family relationships. Petitioner expressed that she is in fact pursuing a separate civil suit against respondent and others. Finally, the conduct at issue occurred too remote in time to form a basis for issuance of a protection order. Petitioner provided evidence that in January of 2022 to April 2022 timeframe, respondent was actively seeking to interfere with her personal and professional life. Additionally, petitioner claims respondent committed perjury during a March 2022 hearing to obtain a sham protection order. Petitioner did not file this action until October of 2022. Without proof of further incidences, these actions are too remote in time to justify the court stepping in and providing redress. Now, petitioner did attempt to show respondent is still actively harassing her. For the reasons that follow, the undersigned concludes none of the instances rise to the level of menacing, but here they are. In August of 2022, respondent went quote-unquote live on her YouTube channel and for 2 hours discussed the issues between the parties, referencing petitioner as her quote-unquote stalker. Additionally, after filing of this action, respondent made comments on social media that petitioner found to be defamatory and disparaging. Petitioner is upset that in one of the posts, respondent falsely claims petitioner was denied an ex parte order of protection. In another post, respondent makes provocative and unflattering remarks about petitioner and her witnesses. Respondent's online activities are distressful to petitioner, especially because she admittedly, by the Colorado Order of Protection, petitioner believes that the respondent has free reign to ridicule and insult her on the internet while she is handicapped in being able to respond. Importantly, respondent is not directly or even indirectly communicating with petitioner. She is not posting on petitioner's social media sites or YouTube channel, nor is she, quote unquote, tagging her internet activities to cause delivery to petitioner. Petitioner apparently became aware of posts when they were sent to her by others. While respondent's commentary may be about petitioner, it is not tagging her. Petitioner did not prove that respondent acted with knowledge that petitioner would see any of the posts. Moreover, the posts do not contain threats of physical harm. Petitioner testified that unknown individuals made threats against her in the comment sections during respondent's YouTube live video broadcast. Petitioner did not admit these alleged threats into the record or provide any details as to the nature of threats. There is no evidence that respondent was purposely riling up these unknown commenters as a means to harass petitioner. These posts are the electronic equivalent of someone, quote unquote, talking about you behind your back. While they may upset the RC, or while they may upset the petitioner, RC 2903.214 was not designed to restrict such behavior when there is no threat to the individual's safety. Additionally, as set forth above, a finding that this conduct meets the statutory definition of menacing by stalking would likely run afoul of the First Amendment. Again, for more appropriate recourse is to petition the Colorado court to terminate its protection order if respondent's internet activities provide any grounds to do so. Petitioner also sought to prove that she is being tormented, harassed, and abused by other individuals who are acting at respondent's direction and control. Petitioner's theory is that respondent engages others to do her dirty work to provide her with quote-unquote plausible deniability. There is proof that these other actors are in respondent's orbit. James Rasakis certainly has an affiliation with respondent, and her own counsel expressed that his conduct appears intimidating. However, the evidence is insufficient for the undersigned to conclude these individuals are acting as respondent's control because Ms. Oriani did not call them as witnesses. Petitioner's evidence demonstrates these individuals bear their own animosity against her, even if their hostility stems from issues relating to respondent or they are acting to defend her. She is not responsible without sufficient proof. She directed them to engage in the conduct as opposed to them acting on their free own will. Sometimes you got to save the proof for the bigger pie. The magistrate understands petitioner's point that these individuals have acquired the transcript and other filings in the Colorado case and spend much time releasing information about those proceedings on the internet. Petitioner stated that the only way that they would get these documents is from the respondent herself. Petitioner did not show that the Colorado court proceedings were sealed or deemed confidential. These individuals are either involved with or have their own YouTube channels. The players all seem interested in the true crime genre. Thus, it is not surprising that the Colorado proceeding caught their attention and is the subject of their broadcasts. She did not substantiate that they are from the respondent. Again, these individuals seem to have a personal disdain for petitioner. Along this subject of respondent using others to torment, to harass her, petitioner testified during the hearing that the process server who came to her residence to serve her with her Colorado court documents engaged in harassing and intimidating acts. While the magistrate does not take issue with petitioner's testimony regarding the process server's conduct, she failed to substantiate that respondent is culpable or in any way controlled or directed the means and manner in which this individual was effectively or was to serve her. So that has been handled. The magistrate will next address an issue raised by petitioner at the close of the hearing. Petitioner argued that the actions of respondent's counsel and the undersigned inappropriately influenced her decision not to call respondent as a witness in her case in chief. Respondent believes she would have had substantiated testimony by respondent if she took the stand. The magistrate notes for the record the following. After the conclusion of Mr. Barnes' testimony, the undersigned asked petitioner who else she intended to present. Petitioner indicated herself and respondent on cross-examination. At that time, respondent's counsel raised a concern due to the existence of the Colorado Protection Order, which presumably precludes petitioner from speaking to or harassing respondent. Again, I want to repeat this because this is very important. The magistrate will next address an issue raised by petitioner at the close of the hearing. Petitioner argued that the actions of respondent's counsel and the undersigned improperly influenced her decision not to call respondent as a witness in her case in chief. Petitioner believes she would have had sufficient testimony to substantiate her case had respondent testified. The magistrate notes for the record the following. After the conclusion of Mr. Barnes' testimony, the undersigned asked petitioner who else she intended to present. Petitioner indicated herself and respondent on cross-examination. At that time, respondent's counsel raised a concern due to the existence of the Colorado Protection Order, which presumably precludes petitioner from speaking to or harassing respondent. The undersigned expressed that respondent was represented by counsel who could object to any improper questions. However, petitioner was cautioned that the undersigned does not have jurisdiction to enforce the Colorado Protection Order and would not be the final arbiter of whether she engaged in conduct that violated the order. The undersigned suggested petitioner present her testimony next before calling respondent. The undersigned's aim was to allow petitioner to lay proper foundation and context to then ensure the relevancy of her cross-examination questioning of respondent. Petitioner immediately stated she did not need respondent as a witness because she had recordings of respondent that would be played during her direct testimony. Petitioner's attitude and demeanor conveyed not that she was being strong-armed, but that she was confident these recordings would be enough proof of respondent's wrongdoings. Petitioner did play snippets of the recordings. Once her direct testimony had concluded, the undersigned asked if she had further witnesses. Petitioner indicated no. The undersigned asked again, and she expressed she did not want to call anybody else. Upon hearing her case, it was dismissed. Petitioner then claimed she was thought from calling respondent to the stand. Petitioner was afforded the opportunity to call additional witnesses. She voluntarily chose to rest her case, and that is true. I did, because I was more or less threatened by her. I took it as a threat that if I call her counsel, if I called her, that I would be subject to violation of the protection order. So I chose not to.
The magistrate also basically instructed you that it did seem like it was a threat. That's what everyone within the sound of Zimmerman's voice took from it. And it was a smart decision on your part to not go ahead with that. It's not worth it.
Yeah. So I had all intentions of calling Miss Walsh to the stand, and her attorney made it perfectly clear that if I did, in my opinion, that they would go ahead and file some shit in Colorado. But those are the facts. I only had Kraft and Barnes as a witness. So anybody out there thinking anything else, that's just not true. Also, I am in a very, very big case. It's a civil matter, as I am suing Unmasked, Vanessa Walsh, and James Rosakis. So, and that's underway, and yeah.
Yeah. So
there's other stuff that's coming out, but that can all. I want to keep everything private. All I can recommend to everybody is that if you don't care for somebody in a chat, if you don't care for somebody's content, the best thing to do is not to watch it and to block people. I think that it's a shame when you have a bunch of grown adults that use their thumbs or fingers to attack people. So, there's no place for that at the Home Team Truth and Transparency channel. So anybody that's going to act as a third party for anybody that is restrained from me, I will go to the courts. That is not a threat by any means. That is just simply saying, I urge you to stay in your lane. That's all. Be a good person and focus on your life and the good things that you have. Nobody needs to be anybody's quote unquote bully or mouthpiece or anything like that. So that's the best thing that I can tell people to do. People need, there's whatever you like in life, whatever you love, give your time to that. Focus on the people that matter in your life. So. I will say there's people out there that want a backstory. There truly is no backstory. You guys know how I work. I could give you a backstory in 69 seconds. Well, it's like 1 minute per line here. I have an affidavit that I've prepared that it basically has all the facts on it. But I was targeted with a smear campaign, and it's because of I was looked at as competition, and they tried to eliminate all avenues of my business, which was the nonprofit that I started and this channel. Um, and then they started contacting family members and doing things to interfere with my custody with my son. They went as far as to saying that I put a hit out on her. And that was really hard to hear. Because no matter if I'm married to that person anymore, I love that person and I'll always love that person. And that's my son's other mother. And for anyone to ever say that, you got a lot of nerve. And that's not going away. So that will be taken up as I am pursuing my defamation claims where I have them. Sorry, my throat.
The best part about that, though, is that was played in court for the magistrate, the quote proof that Lana took a hit out. And we've all been wondering what this proof is, because we've never, ever heard Lana ever say anything like this. And it was played in court, and everybody but the respondent was confused because it was not there. And the magistrate found that is not what was being said. And like the thing I read, she found the opposite, So it's just intentional disruption for no other reason but to cause mental distress. And you have to be, I'm just going to shut up, but yeah. Facts, not an evidence. There's no
facts not an evidence. And that's slander and libel. And it continues to this day. And I've represented myself pro se. I will continue to do it. And I will win. I promise you that. I will win.
She's never lied. She didn't get an ex parte because Lana didn't want to get an ex parte. And this is why that was so frustrating to hear when that person said that she lost in the ex parte. She never went for an ex parte because Lana didn't want to lie.
I didn't lie. I don't lie. I'm not going to say I'm in fear for my life.
She didn't.
I'm not in fear of somebody. I'm not in fear. I was not in fear of that person taking a gun and harming me. So that's not what I was in fear of. I was not in immediate and imminent danger. I'm not going to. I believe in our U.S. Constitution. I believe in each state's laws, whatever they may be in your state, and I would never, exploit those to jimmy rig, to intentionally and maliciously, like what has been done to me. I can prove malicious acts. I can prove, and just like you're hearing in this, everything that I was claiming, I knew that it was not. This is not grounds for. I'm not going to get a protection order for X, Y, and Z because that's not where you get your relief from. You get your relief from filing, a lawsuit that pertains to defamation, pertains to interference with custodial relationships, interference with business relationships, defamation per se. I mean, fraud, abusive process, invasion of privacy. They had somebody, I'm not even going to say.
Yeah, it's better to not say it. But what you guys heard is basically the facts and evidence. And
so what I work on is my case too. So who's a better PI than anybody out there? There ain't one. So.
And thank you all for being
here. The long arm statute in Ohio is very, very amazing. And And for example, if you contract somebody while you're in, let's say, Texas, and you contract somebody in Ohio, that's a business dealing, whether you are a person or whether you are an entity. And then you knowingly know that what they are about to go and set out and do to you is going to cause injury to you. You've just availed yourself to jurisdiction in Ohio. That's just the mere smidget of when you want to talk about personal jurisdiction over somebody and you want to fight personal jurisdiction. Well, you're going to lose, and you will lose, and you are going to lose. I have personal jurisdiction over all three of those people. Period. End of story.
And the magistrate found that already. And the other thing that took so long was Zimmerman arguing for an hour and a half about jurisdiction. And we had to sit there while she kept going about jurisdiction that already was ruled, and she just kept wanting to do it. I mean, I guess that's what she gets paid to do. But
the NDA was forged and is null and void. There is no NDA. Not when you don't sign it. When you don't sign it, it's a void document.
Yeah. Being honest and being in justice and the balance of the scales are, very important. So.
Yeah. So, a person with character and strong morals will never have to lie to win. Yep. You're right, Miss Nine. They're absolutely right. And and I'll stand by this, I've never changed who I am as a person because of them, and I never will. In fact, it's eaten every single one of them up to know that, the moment that I start talking about a case that's actually like in the news, all the cases I cover with the nonprofit, they're cases that nobody gives a shit about, nobody cares about. The first case I ever talked about that was a public case and in real time was the Idaho 4 case. It's the only time I've ever done it. And I got to meet all of you amazing people out there that have become part of Home Team. And I tell Boston, Mod Squad, Maple Beeve, New Orleans Lady, Mike Drop-In, Bumblebee, Scorpio, I tell them all the time, I'm like, everything in life happens for a reason, and you just gotta, whatever happens to you, that doesn't define you. It's how you react to whatever happens. But I do believe that in life you're put in certain situations, and that's just where you're supposed to be. But I will say this, that I know that I'm a special person because of my mindset as an athlete. And I also know that other people that if they were to be in my situation wouldn't have been able to do and overcome the things that people were doing. And people would, I feel like, could possibly like self-harm. And that's what kills me, because I am a strong person. But to the people out there that aren't like that, I'm sorry. I'm sorry that, that people like who I've come across have that capability. And I have all these chats. You guys don't understand. If you guys saw my binders, you guys remember when I went out and bought those 46 binders? I got every damn chat you could ever imagine with all these people in it, printed out, labeled, and dated. And to read these chats and what these people were talking about and what these people were doing to people, I just, it breaks my heart. It truly does. And after my case is all complete, I said I would turn over the stuff to the people, because I think that certain people, I know that these people also affected them. If they were to see this stuff, it's very, very sick. It's very, very sick. But the moment that you came for my child is the moment that you picked the wrong person. You picked the wrong one. I lost my full-time job because of these people. I lost all my benefits. I lost some really good friendships. I've lost a lot of time. I've done everything myself.
That was their intention, though, from the beginning, was for her to.
But the most important thing that I didn't lose is me. I didn't lose who I am. So all you did was motivate the fuck out of me. So thank you. And I did this all while gaining 30 motherfucking thousand subs. 30,000 subs is what I gained while doing all of this and covering the Idaho 4 case. I did all of that while doing all of this. So all you people can kiss my motherfucking ass. Because I'm a soldier. I'm a lover. I will fight for you. I will never fight you. I will fight for you. But I won't engage in your baby games. My parents raised me well. I love my family. I love loyalty. I love friendship. I love fun things. And I love that I can do what you can't. And it's going to cost you. That's what's going to happen. So, again, thank you guys. The only reason I ever put this out here today was because it's been a year to the date that I was hauled into Colorado on 3/7/2022. It's 3/7/2023. The only reason I ever put this out here today is because the hate, it's still there. From the people that are still doing it back then, they're still doing it now. And they're trying to re-up an army. And I will say this, just to be clear, in my affidavit that was submitted, oh, here it is. During the mission, the following people were summoned by Unmask Inc. to act as a direct or indirect agent by means of helping to execute Operation Takedown Land Oriani. The agents are as follows: Jennifer Zimmerman, Melissa Keldrone, Lindsay Mahargue, Felicia Berry, Andrea Powers, Kim Kaufman, Kim Taylor-Pape, Nikki Bradley, Fabio Suzuki, Jessica Mauser, Stephanie Cooch, Crafton Barnes, Lindsay Hensley, Jessica Sang, Jamie Abeda, Sarah King, Jessica Jensen, Kim Coles, Shannon Johnson, Sandy Bezzetta, Ronnie Watts, Cindy Watts, and Sherry, who the fuck knows your last name. All of these people were utilized at some point by Ms. Walsh and Mr. Rasakis and Unmask Inc. over the past couple years to aid in completely ruining my life and Amber Forte. Start being better, start being more kind to people, or stay away. Until next time.
Thank you guys for being here. Thank you, mods. Thank you, Lana, for sharing with everybody what you've been working on for a long time. Today does mark a year. Congratulations for having the heart and the strength to stick through it.
Thank you for saying that nuancely. That's absolutely right. When Lana ever has had to cancel live, this is exactly what I've canceled it for.
Mm-hmm. For her son.
For my son. Anytime I've ever canceled a live, it's for my son. Everything I do is for my son. Love you guys. See you next time.
Good night.
Until thank you, Bella, for being my voice, because I didn't have enough.
I know. I wish I could do more because you're like.
I know. I was like,
That'll be fun. All right.
All right, guys. See you later.
Bye.
Take care. Oh, and by the way, don't fight people that talk about me. Don't say anything. Block them. Ignore them. It's just for you to know the truth. I believe in the truth. If I fight for somebody else's kid, don't you think I'm going to fight for my own? Even 10 times harder? I think so. All right, guys. You guys are the best. Much love.